I want to kind of choose my words carefully here. I've listened really carefully, and I think I've been here as much as anybody else has, if not more. But I still have some questions. I think from my questions and from my comments, I've demonstrated pretty clearly I'm very impressed with you, Your Honor, and I think you'd make a great Supreme Court justice. Some have criticized my friends on the other side for asking you how you would rule in specific cases. And I don't think that's an appropriate question. But if I'm going to be honest, I would have to say I'd love to know the answer to that too. Because we live in a real world. And I can tell you my people, in selecting a president, who he was going to appoint to the United States Supreme Court was one of the main reasons that some of them voted for him. And I can assure you that if you're confirmed, and I think you will be, and you go on the Supreme Court, and I don't think this will happen, but it's happened before, and you act in a way unlike one could reasonably conclude you would act as if, based on what you've said here. I don't know how to put it. If you went on the court and started acting like Andy Kaufman or something, my clients are going to, my constituents are going to have something to say about it. So I don't want the fact that I'm still asking you the questions to be misunderstood, but this is a big deal. I'd like you to walk me through one more time how you would approach construing a statute. Let's suppose a state passes a law that says no law shall discriminate against people on the basis of eye color. I doubt that'll ever come to the U.S. Supreme Court. I doubt a legislature will ever pass it. That's in front of you, and you've got to construe it. What's the first thing? What are the steps you go through?
Senator, I understand entirely the desire of everyone to want to know the views that I might subscribe to personally and get me to make commitments about how I'd rule in future cases. I understand it.
I'm not asking you to do that, Your Honor. I hope you'll understand that.
I do, but I'm not saying there's any improper questions. There are only improper answers. And as a judge, as a sitting judge, I am bound by canons of ethics.
Right.
And I've tried to be as full and as open as I can possibly be, consistent with those canons. And those canons are important. They're important to me because if I did make a bunch of campaign promises here, what's that mean to the independent judiciary? What does that mean to the litigants in front of me? What does that mean for the future of this country? Those things are important to me. And there's a long line of judges who've come before me. And this is an unbroken chain. Mm-hmm. And I don't want to be the weak link.
I understand.
That's important to me. In terms of statutory interpretation, you start with the text of a statute. You look at its plain words. You consider how a reasonable person would understand those words, the affected persons at the time. Right? You look at them, they have a fixed meaning. And you try and apply it according to its plain meaning as best as you humanly can.
Plain meaning to whom, Your Honor? To the lawmaker, to the people who have to comply?
To the people who have to comply, to the average person, the public understanding.
Okay.
Not a private understanding. We don't live in Caligula's world. Thank goodness. Right? Caligula, who posted, as I've indicated before, his laws so high in a hand so small nobody could read them. He knew what they were. Mm-hmm. Secret law. Right? Ours is public law. That's our system, made by the people and their representatives, a government by the people, for the people. And a judge's job is not to become a legislator and rewrite it and fix the problems in it.
What if the words are unclear?
Well, if the words
well, let me stop for a second. I apologize for interrupting, but I'm probably going to be cut off here in a second. suppose the words are clear. Do you just stop?
You stop. You're done. Well, unless you have a constitutional difficulty. You're talking about a statutory interpretation case, though, so I'm assuming we are just dealing with statutory interpretation. And if the words are clear, you stop.
Wouldn't you want to go take a look at the legislative history just to make sure that you're right, that the words are clear?
Senator, the Supreme Court of the United States precedent is quite plain on this very point. If the words are plain, you stop.
In determining whether the words are plain, and look, I'm not about to debate Supreme Court precedent with you. I'll lose handily. But I've read a number of cases that also say it's okay for a judge to take a look not only at the plain meaning of the words, but that legislative history is appropriate. It's not dispositive of what the statute means, but it can be helpful. And it's also okay for a judge to look at a statute and try to imagine what problems the legislative branch was trying to address. And the example I gave last night, admittedly it was late and we were both tired, but I would love, and I'll bet you would too, strike that. I shouldn't have said that. I'll bet many people would love to have a transcript of the Constitutional Convention that drafted our Constitution. Now, if a member of that convention made certain comments and they were written down and we had a transcript, you couldn't go to his comments and say, well, he must speak for the whole convention. That wouldn't be right. That's a failing of legislative history. But you sure, if Benjamin Franklin said it, you'd want to know it. And that's the case where the legislative history or the problems that the drafters were trying to address could have an impact. Do you think if a statute's clear, you should never look at that? That's honestly a question, not a suggestion.
And I take it that way, Senator, and I'm answering it not from my personal preference, but from a matter of precedent. And the Supreme Court of the United States' precedent on this is plain, happily. This one I can give you. If the statute's clear, that's the end of the interpretive exercise for a court, period. Period. You're correct that if there's an ambiguity in the statute, then a court will look to other tools, canons of construction, perhaps the legislative history. There's a debate over how valuable that is that we've all discussed several times in the last few days, and the value and some of the issues associated with that. I respect very much the work of this body. When I'm a judge, I like to get every scrap of information anybody wants to put in front of me. I read it all. I take it all seriously. There are problems we've discussed with perhaps too much reliance on legislative history, the due process issue, right, that we've discussed, the Caligula problem, the fair notice problem, the bicameralism and presentment issues we've discussed in separation of powers. It's not the law, but you look at everything somebody gives you. A judge doesn't say, I'm not going to read that brief today because I don't like the color of the brief. You know, it should be a lighter shade of blue. You know, I look at all material put before me. But when the statute's plain, Senator, the President of the United States says to the judge, stop.
Okay. And when it's not plain, which I think is oftentimes the case, well, many times the case, we can probably agree on that. If Senator Tillis or Senator Coons or Senator Franklin passed a bill and it's not clear, then would it ever be appropriate for a judge to say, okay, it's unclear, I'm going to take a look at legislative history, but I'm also going to try to, through looking at the legislative history, try to understand what was the problem they were trying to solve? Is that ever appropriate?
Senator, I'm not sure what you mean by that, to be honest with you.
Well, why did they pass the statute? Would you ask yourself, why did they pass the statute?
Well, one concern I have with that enterprise is I have a very difficult time getting in the head of anyone else. And trying to get in the head of 535 of you, plus a president, well, frankly, Senator, that's often beyond me.
Okay. Let me switch to another subject, the Third Amendment. I don't remember the language, it's quartering troops. It hasn't gotten a lot of attention, and there hasn't been a lot of jurisprudence on it. But some think that it has privacy implications. Have you given any thought to that?
Senator, I think it does suggest, hey, my house, is off limits to your troops. There's a privacy implication in there. Yes, I do.
Okay.
Yeah, yeah.
I think Justice Douglas cited it in, it was either Griswold or one of the privacy kind of cases. All right, let me ask you this. I want to talk to you a second about state action. I don't need to tell you, you know better than I do, the Bill of Rights protects us against government. Some state constitutions have bills of rights that actually establish our rights vis-a-vis each other as individuals, but the federal Bill of Rights doesn't do that. It's our protection against government. What's your feeling about the state action requirement? What do you understand a state actor to be?
Senator, you're going to have to help me out. In what context are we talking about here? State action requirement is, the protections of the Bill of Rights are as against the state.
Right.
Against the government.
Right.
Yeah.
Right.
Yes. If that's what you were getting at, yes.
Yes.
Yeah. They're rights as against the government. They're protections as against the government.
Okay. But sometimes there are entities that are alleged to be acting in the shoes of the state, agents of the state.
Yes. Yes. That's an interesting problem, right? Because Congress today has created a multiplicity of arrangements. And is it government or isn't it government? It's actually a question that arises from time to time. And if you'd like a look at what I've written in the area, I might refer you to U.S. versus Ackerman, another case where I ruled for the little guy, maybe, if you like. And it had to do with whether the National Center for Missing and Exploited Children is a governmental entity. And the line of cases in the Supreme Court goes all the way back to the Dartmouth College case. And it's a fun read in terms of the Dartmouth College case. What qualifies as a governmental entity? The Supreme Court of the United States recently struggled with the issue in the context of Amtrak. So there are questions around this area as to what is government and what isn't. Very important, because if something qualifies as government, it has to square its corners under the Constitution and the Bill of Rights, of course. So, for example, in the Ackerman case, if NCMEC's a governmental entity, it needs to comply with the Fourth Amendment. Can't invade personal privacy without complying with the warrant requirement, for example. Yeah. So they're very important questions as to what is and what is not a state actor.
Yeah. Well, I want to be clear for the record. You mentioned the little guy, and I know that's come up a lot, and everybody's entitled to their own opinion. I was taught justice is blind, and it doesn't matter whether the party is, it doesn't matter its wealth or its status or its power. You decide cases on the basis of the law. I mean, Lady Justice is wearing a blindfold. So I agree with you completely on that. I understand the other point of view, but I don't agree with it. Your book on euthanasia. Could you, kind of like you're talking to a 10th grader, give me a summary of your thesis in your book?
I can try, Senator. I find it a very hard issue. It's one every American has deep and understandable views about. It concerns the end of life.
You can pull the mic just a little bit closer.
I'm sorry. Of course, I apologize. The end of life, which we all face.
Yeah.
It's a problem all of us face. And it's a book in which I struggle with the end of life issues that we all face and how we as a people might consider resolving them. Wrote it before I became a judge, as a commentator, with my thoughts as an individual, not as a judge.
Well, what I read of it, as I told you last night, I didn't read the whole thing, but I read parts of it. It's very well written, and it is something that we all have to deal with and we all think about.
Yeah, And I don't, I appreciate you having read some of it. I suspect until about a month or two ago, it hadn't been exactly widely read.
I have a feeling it is now, Your Honor.
Well, I expect it'll make a good door jam for most folks. But I conclude that there is a very important interest in being left alone in life, and that there's an understandable and appropriate zone of privacy there that we need to respect. And we've all experienced it when a parent or grandparent wants to go home. Had enough. It's time.
And your thesis, once again, not to replow old ground, but want to be sure to understand, is not based on religion.
Goodness knows
It's
that.
secular, it's based on your secular moral values.
Well, it's not even my, it's an attempt to work
I don't mean to
through-
imply they're yours. It's based on, not your thesis is based on secular moral values.
Yes.
That once you cheapen life, once we become desensitized to taking life, it's easier to take the life of those who are less powerful than you and I.
Senator, that's one worry I expressed, and that the difference between refusing treatment and killing people raises with it questions about what happens to the least amongst us, the vulnerable, the elderly, the disabled. And I don't profess to have the final answer here. I'm not a philosopher king. But I do know that when you have a more expensive option and a cheaper option, those who can't afford the more expensive option tend to get thrust into the cheaper option.
Yeah.
And so those are some of the concerns I worked through. It's a long book, it's complicated, and I do not profess to have the right, final, or complete answer. I hoped at most to contribute to a discussion on an unanswered social question where all people, and I do think all people, have a good faith interest in trying to reach some consensus socially on it.
Well, it was well written. What I read was very well written. Got you an Oxford D.Phil. It was your thesis, wasn't it?
More or less.
Yeah. Well, it got you an Oxford D.Phil. That's pretty good. How am I doing, Mr. Chairman? Okay. I'm going to yield back my time. Thank you, Your Honor.
Thank
I
you,
appreciate
Senator.
it very much.